Hi, everyone. Thank you so much for joining. We're going to wait just a few more minutes to let some more people in. Going to give it just one more minute. Thanks for your patience, everyone. Make sure we can get everyone in here. All right. So I think we're going to go ahead and get started. Thank you so much, everyone, for attending this evening. My name is Hannah Stern. I'm the Policy Associate at the ACLU of Rhode Island. I'm very excited to have everyone with us tonight, our attendees and our panelists for our preview of the 2022-2023 Supreme Court term. I really think this is going to be a very interesting and informative night for all of us, myself included. But before we begin, I just want to go over a few things. We are glad to offer auto-generated captions for this virtual event. Please just keep in mind that there are sometimes inaccuracies with this service, but we do think it's still a very valuable tool for our attendees. To enable captions, you can click on the live transcript button at the bottom of your Zoom video screen. And as usual, we have reserved some time at the end of this webinar for questions. To submit a question, it's just as easy as clicking on the icon marked Q&A. Then you just type your question into the box that pops up, click return. All of those questions will queue up on our end, and we will try to get to as many as possible at the end of the webinar. And then finally, just before I introduce our panel for this evening and really get us started, I also just want to introduce the wonderful Megan Cachadorian, who is the assistant to the director at the ACLU of Rhode Island. She's our technical director for this event, AKA she's doing the PowerPoint that's on your screen right now. So I just wanted to make sure that I introduced her before we moved forward. But we also have a wonderful panel of individuals tonight to talk about what we can expect from the 2022-2023 Supreme Court term. So I do just want to briefly introduce our panelists. First, we have Stephen Brown, who's the executive director of the ACLU of Rhode Island. Next, we have attorney Sonia Dio, who is a solo practitioner in Providence. She focuses on employment discrimination and civil rights types of cases. Just as a quick side note, attorney Dio will have to leave us as soon as she's concluded her case. So I just want to take the opportunity now to preemptively thank her for joining us tonight. We also have Janet Gilligan, who has been practicing law for the last 44 years. 36 of those years were spent at Rhode Island Legal Services, representing parents caught up in the child welfare system. For 15 years, Janet taught family law at Roger Williams University School of Law as a member of the adjunct faculty. We also have Diana Hassel joining us this evening, who has been a member of the faculty at Roger Williams University School of Law since 1995. She teaches in the areas of constitutional law, civil rights litigation, and race in the law. Professor Hassel received her JD from Rutgers Newark Law School and has a BA from Mount Holyoke College. We also have Deborah Gonzalez with us tonight, who is the director of the Immigration Law Clinic at Roger Williams University School of Law. She's also an ACLU of Rhode Island cooperating attorney and board member, and has been involved in major litigation addressing the Wyatt Detention Center and detainees' rights during COVID. We have Lynette Labinger as well with us, who is a longtime ACLU of Rhode Island cooperating attorney and a very well-known civil rights lawyer who, over the course of a few decades, has successfully litigated numerous challenges to state anti-abortion laws. And last but not least, we also have Jamie Rhodes, who hung his shingle on his own solo law practice, Rhodes Consulting. He works primarily in the environmental field on projects regarding purchasing of renewable energy, utility regulation, and creating a circular economy for consumer goods. Each election cycle, he also regularly works for candidates and organizations engaged in the election process. And Jamie is also in his second term as a board member for the ACLU. So I just want to sincerely thank all of our panelists for taking the time to join us this evening and for lending us their expertise. But before we jump into next year's session, the 2022-2023 SCOTUS Supreme Court of the United States session, we actually thought it might be helpful to remind everyone of, candidly, the fairly devastating impact of the 2021-2022 Supreme Court term on civil liberties. So I'm going to turn that cheerful conversation over to our executive director, Stephen Brown, just to briefly provide us a reminder of where we were left when the previous Supreme Court term concluded this last June.
Thank you very much, Hannah. Thank you, everybody, for joining this webinar. I hope you find it informative. As Hannah said, before we look ahead to the bad things that may be awaiting us, it's worth taking a quick look at a few of the things that happened this past term that are somewhat problematic. Commentators said that this was the most conservative court in about a century. You have to go back to the 1930s when the Supreme Court was overturning all of FDR's plans to get the nation out of the Depression. And I think some of the cases they decided shows that. And I just want to highlight very quickly a few of them. The first and most obvious one is Dobbs versus Jackson. This was the case that overturned Roe versus Wade. And I think the decision had a number of elements to it that I'm concerned and fear we will see more of in the coming session. And those elements included such things as a very apathetic, is a mild way to put it, but an apathetic approach to precedent if it gets in the way of an outcome that this conservative majority wanted. They just threw out a 50-year precedent with little remorse. They relied on this so-called theory of originalism, that you go back to the origins of the Constitution to figure out what rights were available then to decide what it means now. That's not only bad in this context because they were looking at a history where women who were affected by abortion laws now had absolutely no right to vote, but they also cherry-picked the history of abortion in this country in order to get to the goal they wanted. The decision also puts a lot of other precedents under a dark cloud. If you start saying we have to go back to when the Constitution was adopted, where does same-sex marriage, interracial marriage, all of which were struck down, where do they fit in since they were allowed at the time of the Constitution? As the dissenters argued, there's a real fear that it undermines the legitimacy of the court by issuing such a far-ranging decision like this. The court also took us backwards in two cases dealing with the First Amendment, and particularly the issue that gave Roger Williams claim to fame, and that's separation of church and state. The first case they decided was called Kennedy versus Bremerton. It was a school prayer case, and it involved a high school coach who at the end of games would run out to the 50-yard line, kneel and say a prayer that was often joined in by other students on the team. Some team members who felt uncomfortable participating and sort of felt coerced to doing it challenged it. There have been decades of court cases, including one from Rhode Island, where the court has said prayer and public school don't go together. But in this case, the court sort of twisted what was happening and said that this coach was simply acting in a private capacity after the game and exercising his own personal First Amendment rights. The only hope about this case is that they twisted the facts so much that it may not mean much for other challenges of religion in schools. Unfortunately, the second church-state case they decided, Carson versus Macon, was a real setback when it comes to taxpayer funding of religion. In Maine, the state has a system set up where in certain rural areas, there are no public high schools. And so the school districts send the students to other private schools. And if they do that, they provide funding to go to the private schools. But for decades, they had said, we will not provide funding to religious schools. You have to go to a private secular school if you want to get funded. But the Supreme Court, in one of its many 6-3 decisions, overturned that statute. And in overturning the statute, they also turned the First Amendment itself on its head. It was always the idea that the First Amendment prohibited government funding of religious institutions. What this Carson decision says is the government is actually required to fund religious institutions. Very, very dangerous. And we'll have to see where that takes us in the future. And then finally, I just want to very quickly mention 2 other cases, Vega and Egbert. They're very technical cases, but the bottom line is a problem that's been occurring ever since the Berger Court. And that is the court coming up with technical rules to prevent people from being able to remedy civil rights violations when their constitutional rights are violated. Just to mention the Vega case, that involved a person whose Miranda rights were violated. Everybody acknowledged that the police failed to give him his Miranda rights before he made incriminating statements. He was found not guilty, despite those statements being introduced in court. And after the case was decided, he filed a civil suit against the police. And the Supreme Court said, sorry, there's no remedy for a violation of Miranda rights. Go to Congress, get them to pass a law, and then maybe we'll consider it. And they did a very similar thing in the Egbert case. And it's important, these cases are important because people aren't following them. They may not understand them, but the impact is incredible in terms of preventing people from being able to vindicate their civil rights. So with that very depressing summary of just a few of the cases from last term, I'll hand it back to Hannah so you can hear about what's coming up this upcoming term.
Thank you so much, Steve, and thank you for that summary. So like Steve said, we're going to turn now to the impending 2022-2023 SCOTUS term. But just to provide a little bit of context to the cases that you're about to hear about, these are those cases that the Supreme Court has already indicated that they're going to definitively hear during the upcoming term. There's still a really large likelihood, actually, that they will agree to hear other controversial cases before they begin the October term. So as significant and controversial as the cases that we will be speaking about tonight are, they may only be the tip of the iceberg of what this upcoming term really could bring. So now that we've lightened the mood even more, I'm going to ask Sonia Dio to start us off with an important case concerning both LGBTQ+ rights and First Amendment rights. And again, I'll just thank her in advance for joining us, as she will have to leave as soon as she's done discussing her case. But thank you again for everything you're about to tell us.
Sure. Well, thank you. Pleasure to be here tonight. I took a look at this 303 Creative LLC case, and under any normal circumstance with the court as it was constituted a couple of years ago, I would say to you that they would look at this matter and say, there's no injury here yet, so there's nothing for us to hear. And that certainly was how the lower court decided the matter. What happens is you have an individual who has some religious beliefs and is in the business of creating sort of websites for individuals and putting forth other projects. And they come across this Colorado anti-discrimination law. And they say, look, under this law, if somebody comes to me, it's going to offend me in my religious beliefs if I have to put together a website for them that would advertise their desire to get into a same-sex marriage. And they bring this to the district court, and the district court decides, much as I've just said, that there's not an injury there. It goes up to the 10th Circuit that says, well, you know, there's an injury in fact, but that under the Public Accommodations Act that's put forth in Colorado, that the statute passes what's known as a strict scrutiny analysis. So that means that the statute itself is created in such a way that while it's acting towards preventing discrimination, in other words, any person that goes to an individual that is publicly selling an item would be able to get that item. Therefore, the statute's factually neutral. And this incidental effect on the individual's first free speech rights, that they might have to provide a website that serves same-sex individuals, does not rule the game. Now, of course, we're with the Supreme Court that has indicated that in some ways they're hostile to these sort of ideas. We don't really know what's going to happen. The argument from the other side is that, look, even if this is an anti-discrimination statute and impinges upon somebody's First Amendment rights, either to engage in speech or not engage in speech, by requiring them to create a website in this instance that would serve same-sex individuals when they don't want to, because it's against whatever their beliefs are. The ACLU has taken the position that if 303 Creative LLC were to succeed in this matter, basically the entire statute would be riddled full of holes. In other words, you could come up with 15 different reasons why anything you're doing has part creative content. And if you have free reign in creative content and whatever you're doing, you would be able to discriminate against anybody who is coming to you when you're providing any service. That's essentially the case. Really quite concerning. We have a very similar act here in Rhode Island. Our act does not have some of the exceptions, actually, that the Colorado one does, in particular for religious freedoms. But both acts prevent groups from either putting up signs saying that they won't serve certain groups or advertising they won't do things like that, and require that if you're offering services to one group, that you offer services to all comers. So this is really quite concerning. And I'm sure this will come up later on, and it certainly has in Dobbs. But, you know, our statute, it might be declared unconstitutionally here federally, and it's not as if we could do something to, you know, change those rights because of the very nature of what this is going after. In other words, you can't cause somebody to engage in speech or restrict speech at a state level in a way that would be fundamentally different than what's done at a federal level, I think. So that's sort of what's going on with that. And it's certainly something that I'll be interested in watching. And let's hope that we can keep our discrimination statutes in effect. Thanks.
Great. Thank you so much for that wonderful summary of that case. We're going to move on now to a case concerning affirmative action. So I'm going to turn it over to Diana Hassel to speak about this case. Thank you. I think you're on mute.
I should know that after all these years, shouldn't I? So the case is Students for Fair Admissions versus Harvard. There is also a companion case with the same plaintiff, Students for Fair Admission versus the University of North Carolina. And in this case, I think it's fairly certain that the Supreme Court, the current Supreme Court, will overturn Grutter and Bakke, will overturn a 45-year precedent. The law, as it is most recently affirmed in Fisher in 2016, said that race can be under both the Equal Protection Clause and consequently Title VI of the Civil Rights Act, which applies to private schools who take federal funds, that race can be used as a factor in admission in undergraduate and graduate schools because there is a compelling state interest in diversity in education. And the court has deferred to the judgment of universities that such diversity is important for the education and for the educational outcomes of their students. That was first established in Bakke 45 years ago and has been affirmed in Grutter and most recently in Fisher. there's a strict scrutiny standard applies, diversity is a compelling state interest, and then the school has to go about using race in a way that's narrowly tailored. That's been the standard, as I said, for 45 years. In this case involving Harvard, the questions presented to the Supreme Court are explicitly, should we overturn Grutter so that race may not ever be used as a factor in admissions? The secondary question in that case is about intentional discrimination against Asian American applicants. In the University of North Carolina case, there's again overturned Grutter, and also a question about what kinds of race neutral alternatives, even if we're applying strict scrutiny and the admissions process has to be narrowly tailored, what kinds of race neutral alternatives does the college or university have to consider? I think it is almost certain that this will be decided either 5-4 or 6-3 to overturn Grutter. And so then we will then have a precedent that says race may not be used in admissions in higher education. I think there's in any other situations where race has been a permissible factor in some kinds of contractual set-asides for government funding and other situations, those will be on the block next. So it's going to be a very another kind of aggressive overturning of a practice that virtually all colleges and universities in this country are using, and it is going to result in less racial diversity in higher education.
Great, thank you so much for that summary. Before we move to our next case, I just want to quickly remind everyone, all attendees, that you can submit questions as we're going through the presentation. We are doing all questions at the end of the webinar, but you can please feel free to submit them. If anything comes up while you're hearing any of our speakers, please feel free to submit it to the Q&A chat and we will get to it at the end. So our next case concerns Indigenous rights, and I'm going to ask Janet Gilligan to please speak on that one. Thank you.
Thank you. The case I'm talking about tonight is Brackeen versus Holland, although that is only a glimpse of the cast of characters involved in this case. There are at least 7 individual plaintiffs, 3 states are involved, and several tribes are involved as well. And then the Fifth Circuit got it. So we'll talk about that a little later. So at issue in this case is whether the Indian Child Welfare Act, fondly known as ICWA, for those of us that have to say it more than once in our lives, whether it is unconstitutional, basically on 3 discrete grounds. The first question is, does the placement of a child preferences that are spelled out in the statute, are they unconstitutional because it is in fact a racial classification and as such discriminates against others? And the second question is, does the fact that the placement processes and preferences must be followed, does that exceed the plenary power that the United States has over Indian affairs? So that's number 2. And number 3 is, does the fact that there are certain activities that state actors must engage in to follow the ICWA requirements, does that create a problem of commandeering state actors, which it would be in violation of the 10th Amendment? So now, these were not the issues that necessarily arose at first when this went from the District Court of Texas to the Fifth Circuit. It went to the Fifth Circuit. I keep wanting to say First Circuit, but we wouldn't be in that problem, right? If it was. But the Fifth Circuit chose to hear it in a panel at first, and then after being there for a while, one of the judges on the panel requested that the court hear it en banc, which they decided to do. And that has been going on. So this case has been going on quite a while. In fact, the child, who was like 16 months at the time, is probably 4 now, and he was adopted by the petitioning parents in that case. So that's what we're looking at, is this statute unconstitutional on those bases. It is the Indian Child Welfare Act was enacted in 1978. Not everyone is familiar with it. It was passed by Congress and has been fully operational since then. Every state has their own way of dealing with the equal requirements. Now, it primarily concerns children in danger of being removed from their home, from their family, children in foster care already, or children that are in danger of their parents' rights being terminated. And when I talk about placement preferences, that's what I'm talking about. And these are for Native American children. It only applies if you are already enrolled in a tribe or you are eligible to be enrolled in a tribe. So it's a small percentage, really, in the whole child welfare population, but it's a very significant one. And going back to why the act was passed in 1978, Congress had hearings and they issued congressional findings on the need for this bill. And it basically said, we have we being the government, have an intimate relationship with the Indian tribes. And we have seen how Native American families have been routinely broken apart to a disgraceful degree. And we want to continue to protect Native American children. At the time, it wasn't as bad as it was maybe ending in the 40s, but it was still very bad in that families would be broken up, their children would be taken. And in the early part of the century, the children would be put into boarding schools where it was forcibly sometimes. The parents had no say about it. They couldn't speak their language. They couldn't go by the names they were given, excuse me. They were given names like Steve and Tom and ordinary names. And it was, as you can imagine, very, very destructive and a horrible situation for those people to be in. So if you're a member of the tribe, the state agency, whatever it is that handles those children, must do certain things. Number one, they must send out a notice to your entire family. They must send out a notice to your tribe, because remember, you have to be either eligible to be a member of the tribe or already enrolled. And what happened in the particular case here is that Mr. and Mrs. Brackeen were foster parents. They are not Native American, but there were no Native American families that they could find that would take this little boy, or extended family that would take him, because the preferences are, number one, the child's extended family. So if they can find extended family, they will place the child with him or her and them. And then the tribe, if you don't have family members, if the tribe intervenes, that supersedes the state agency and proceedings there. And after that, it's in a Native American foster home or a foster home that's been approved, or adoptive home that's been approved by Native American organization. And so these folks were not Native American. They unfortunately or fortunately, I mean, in this case, who knows, no one came forward. His parents were both of different tribes, fully enrolled in tribes. Neither of those tribes came forward. Nobody did. But they kept trying to find extended family, and they would set up a placement like one time halfway across the country, and then it fell apart, which these placements often do. So the Brackeens filed the suit initially. And they're in Texas, and the state of Texas joined in, and they are plaintiffs now, as well as is, I think, Louisiana and one other state too. He had been with them for some time, and they thought it would just be a great idea. And it went to court, and there were standing issues at every step of this case, because like in this case, they had already, by the time it got to the Fifth Circuit, they had already adopted him. They had completed the adoption. The Brackeens tried to stay in by saying, oh, well, we would like to get another Indian child in the future to try to preserve their standing. And that worked sometimes, and it worked not other times, because of the two sessions, if you will, long sessions at the Fifth Circuit, especially the en banc decision, which is hundreds and hundreds of pages. I meant to set my timer, but I didn't. I think I'm starting to get the look. So finally, the decision came down that it is not a violation of equal protection to make these classifications apply only to Native American children. For the reason it is not a racial classification in this case, it is a political classification. And that they cite for that opinion the long history of the special relationship between the United States government and their duty almost to protect the children. So not a problem with EP, not at all. And they found, however, that it's one of the preferences that an Indian or a Native American foster family or a Native American approval from an agency was a violation of due process, and that was unfair. So the extended family, the tribe stayed, but the any Native American went. And also the commandeering, they said the fact that they have to spend money to file these records, one was a record keeping situation, nothing very onerous, made it so that it is commandeering, and they can't do that anymore. But you know, the interesting thing is there's a real fear of what we will go back to if ICLUA is found to be unconstitutional by the Supreme Court, of course. Because, you know, one thing I found so interesting, and as a part of the facts, is that how the Brackeens won their adoption hearing is by proving to the Texas version of family court, whatever it is, that they had more money than any of his Indian or Native American relatives. And the lawyer in the case in Texas said, well, that means you get them. You know, you have more money. That's part of our best interest analysis. Whoever has more money is going to be a better parent. So I think that's a modern version of the preference for non-Native families. You know, the lifestyle is different. The culture is obviously different. Most economic styles can be very different. And the part about the requirements, none of them are very onerous. Based on other statutes and other requirements in the child welfare system as is, that's what they're supposed to be doing in every case. They're supposed to be working hard to reunite every child they take with their families. They're supposed to be looking first to extended families and see if your old crazy aunt or uncle can take you, or whoever can take you. So I think it is not really very different, and certainly not onerous. And it's been going on for quite a while. Every child in Rhode Island, and we have a small population that goes Native American that goes into care. The first thing DCYF, the first worker who runs into the family, checks if they're have Native American heritage. So that is that case. I think it's very interesting. And I don't know what they're going to do. I would not pretend to suggest I know. But my real question is, how are they going to hear all these issues, all these cases, all these fact patterns in an hour? Because they've put the consolidated 4 cases in for 1 hour of argument. So that's really going to be the feat. So thank you.
Yeah, thank you so much. We really appreciate that. That summary. That was very comprehensive and very helpful, even for my purposes. So thank you. We're going to turn now to another case involving immigrants' rights, and I'm going to ask Deborah Gonzalez to summarize that one. Thank you.
I was on mute. Okay, so thank you for inviting me to come here. I know that Steve started off this session with saying that everything was so bleak, but I have to admit that when it's Biden v. Texas came out, I was pretty thrilled, and so I was pretty happy about it. And so what Biden v. Texas did was it basically allowed DHS, the Department of Homeland Security, to end the MPP program that Trump had put in place back in 2019. And so for those who don't know, it was the migrant protection program that went into place that allowed DHS and CBP officers at the southern border to send foreign nationals back to Mexico if they were awaiting asylum hearings, even if they weren't from Mexico. So there's a provision in the Immigration Nationality Act under Section 1225B2C, and I'll be referring to it as B2C, that allows the government to send back foreign nationals who are arriving at the border without proper documents and seeking asylum. Now, in the past presidents have always said and have always interpreted that section to mean that they would only do that on a discretionary basis, meaning that the officer has the ability to decide if they're going to send that person back to Mexico. And it's always been understood that they would only send back people that were from Mexico. What was interesting about this policy is that the Trump administration said absolutely nothing about sending people back if they were coming in from Canada. So I think that sort of gives you a flavor, not that we all don't know what Trump was doing at the time. So anyways, when Biden comes into office in January of 2020, he issued, 2021, he pretty much suspends the MPP program, which had put in the program 68,000 migrants, which meant that there was 68,000 new people now living in Mexico. Having been at the border myself, I can tell you that they were living in tents in a park. That's really exactly what was happening with children there as well. But during the Biden administration, once he came into office on January 2nd, which I think was like either the first week or maybe the second week that he was in office, he suspended the program and issued an executive order to create a comprehensive study and framework to address the issues of migration, to manage migration, and to provide a safe and orderly process for asylum seekers. And so with that, he terminated or suspended the program. Well, in April of 2021, the state of Texas and Missouri sued the Biden administration on the basis that the memo that suspended the program was in violation of the American Procedures Act, the Administrative Procedures Act, and the immigration laws, in that under the APA, the Biden administration needed to have put out for notice and comment that they were going to suspend and or maybe terminate the MPP program. And the violation of the immigration laws was that Another section of the Immigration Nationality Act under 1225B1B, and that one I'll refer to as B1B, requires that any foreign national who comes to the border, any border, who does not have a proper documents and is seeking asylum must be detained. So B1B says that they must be detained if they're seeking asylum at the border and don't have proper documents. And B2C says if they're from a contiguous country that they can be returned to that country at the officer's discretion. So Texas and Missouri say, well, you know, you didn't put this out for notice and comment. You're in violation of the APA. You can't change this procedure that the government has been, or that DHS has been following since the Trump administration. And by the way, you're violating the Immigration Nationality Act by either not detaining them, and then if you're not detaining them, then you're not sending them back, and you're not supposed to do that. So they go to court in the Northern District of Texas, and of course the district court, you know, the Fifth Circuit, you gotta love the Fifth Circuit. The Fifth Circuit says, well, excuse me, the District Court of Texas says, well, we agree with Texas and Missouri. Biden administration, you did not put this out for notice and comment, and we're issuing an injunction. You cannot suspend MPP program. And so the Biden administration was required to start the program all over again. Well, after the injunction, well, excuse me, after the lawsuit was filed, but before the injunction, oh my God, I already went through my 5 minutes. I haven't even started. That was my timer, but I'm going to keep going because I haven't even gone to what I need to say. So the Biden administration put out a memo in June saying, you know, we're terminating this process, and they go through this lengthy description as to why they were terminating the process. So the district court issues the injunction anyway. The Biden administration files an appeal with the Fifth Circuit saying, no, you can't do that because we issued this order, for whatever arguments that they were making at the district court level. But while the case is pending in the Fifth Circuit, Mayorkas, who is the Secretary of the Department of Homeland Security, issues another memo in October and says, well, I'm rescinding the June memo and I'm issuing this new memo. And this new memo gives all the reasons why we should terminate the MPP program based on the concerns that the district court had. And so we're terminating it. And now we've addressed what the district court said, and we're starting anew. And by the way, Fifth Circuit, you need to now dismiss the original case. And the First Circuit says, no, we're not doing that. We're not dismissing a darn thing. We agree with the district court. You know, you need to follow the APA, and you're violating immigration laws because you're not detaining them. Well, they filed an appeal with the Supreme Court, and the issue with the Supreme Court was, number one, whether or not the October order was a final agency action. I won't get into that. I don't have time. And whether or not they were violating Immigration Nationality Act. Now, the government had argued that because these two sections, B12 and B2C, fall within the same section of 1225, that the court needed to have read that to say, if the government isn't following the law under B1B, then they must follow the law under B1C, B2C, and the court needs to say that they must now return people to Mexico, even when the language of the statute is very clear that that's a may, right? It's under the discretion of the officer. So the Supreme Court ultimately found that that it was a final agency action. I won't get into that, but that the governments did not violate the Immigration Nationality Act because the statute says that they may send people back to Mexico, not that they must. So the real issue in this case, and why I think this is going to be a problem, I think, in the next session, is that the case was remanded to the district court for them to decide whether the October memo actually followed the APA notice and comment. And I don't think it did. They never put it out. The Biden administration never put out the new memo out for notice and comment. They really just put the memo out there. And so the question becomes now at the district court level, you know, did they follow the APA? I think the answer to that is going to be no. But then the question becomes, I think in my mind, as I view this, you know, are there exceptions to the APA? I'm not an expert in the APA, so I don't know the answer to that. But, you know, I think more importantly is, did the Biden administration have enough reason to do what they did without going through the APA, because there was a humanitarian crisis happening on the Mexico side of the border, and that Mexican and US relations were being impacted by this policy. So we'll have to see what ends up happening. And I'm sorry that I went over my 5 minutes.
No, thank you so much for that wonderful description. I know we all really appreciate it, so don't worry. We have 2 more cases to go over. I'm going to turn it over to Jamie Rhodes now to talk about a voting rights case that is before the Supreme Court next term.
All right, Hannah, thank you so much for passing it along. So yeah, my job here tonight is to try to explain Moore v. Harper and this thing called the independent state legislature theory. And I could leave right there and just say that's got to be the end of it, but we'll dive into the case just a little bit. So this is a case coming out of North Carolina, and was originally was a legal challenge to gerrymandered maps in North Carolina, Republican gerrymandered maps. The Supreme Court originally rejected the maps and said this doesn't fit our constitutional structure. The legislature said, try us. Thanks for sending it back to us. We're going to send you pretty much the same thing. And claim that we've done what you've asked. And the Supreme Court at that point said, that's enough bites at the apple for you. We're going to appoint a special master to redraw these lines fairly. And those are the maps that are currently in place for the 2022 election. Now, the Republican legislature, the leaders of the Republican Party in the legislature, on behalf of the legislature, then appealed the North Carolina Supreme Court ruling, saying that essentially the state courts in Rhode Island have North Carolina, that's interesting, but that the state courts in North Carolina, in fact, no state courts anywhere have the authority to review the legislature's setting of the place, time, and manner of elections. And though this has generally been a debunked legal theory, it seems to have come back to life with this new Supreme Court. And they're getting a shot at making this argument once again. So with to take a step back of what is this theory that they are proposing, it is out of Article 1, Section 4 of the Constitution, which states that elections for senator and representatives shall be prescribed in each state by the legislature thereof. This was cited by one of the more interesting citations to this was in Bush v. Gore in 2000. Well, the Supreme Court said this is kind of a one-way ticket. You can't really use anything we hear to cite as precedent. Just like everyone then said, yeah, you say that, but we don't really believe you. It just took about 20 more years for somebody to say, yeah, so we're going to cite to that. And it just happens to be Brett Kavanaugh, who may have had something to do with the case originally, now sitting on the court and being the 4th vote to say, you know what, this deserves some review. And the theory, the election theory that state legislatures have essentially plenary power within the state to set the time, place, manner, and all things according for the elections of federal representatives, so congressmen and senators. Now, just to give the other side, just for a moment, give it a little bit of credence, if there is any there, but just to give it a moment, is that it still provides for the ability of federal courts and Congress to provide oversight over how a state prescribes these federal elections. And so with that theory, it says like they're supposed to be able to check the legislature, but since the Constitution says the legislature is going to set these standards, that no other state entity, legal or government entity, has the ability to provide any oversight, check, or balances to what the state legislature prescribes for these federal elections. This is the same, well, not the same makeup of the Supreme Court, but interestingly, in 2015, the Supreme Court had already decided in Arizona that allowing independent redistricting commissions, that's okay. That doesn't violate anything. And now we are 7 years later where they're essentially saying that we're going to see if this proceeds, likely an overturning of these precedents that say anything but the legislature deciding how the elections take place would be unconstitutional. So the practical impact of this really depends on which form of media that you want to take in to say what the impact is going to be. The general thought is that any state court review of state election laws would be invalidated. Just blanket, that the state courts had no authority to actually review these laws. They had to be in federal court, or Congress had to be the ones to do it. I can't tell you the number, like it's pretty much impossible to go down the number of places where states have said the legislature might be violating, say, its own constitution in setting these the methods of elections. But this theory would essentially say that's fine. A state legislature is not bound by anything except the federal constitution and the federal courts in setting the elections of federal representatives, and that the state constitutions essentially have no say in it. That seems, I think the word I would use is crazy making, to say that one entity in a state has all the authority to set something as important as elections. But that is exactly the theory that they're pursuing here. It appears that with these 4 votes to grant cert for this case, the deciding vote is likely to be Amy Coney Barrett in this one, and that the other folks on the court have already made their positions known and doesn't seem likely to change their position. But with the new justice, they might play an oversized role in whether state courts are ever able to review the method of electing federal representatives in the states. So there's a lot to look forward to. Practically in Rhode Island, what would this, it's hard to say what this would do, given that our legislature and our courts there hasn't been a lot of fighting over the time, place, and manner of our federal elections. But it would say that it would give our legislature, which has plenty of authority and power already, just a little bit more in setting our federal elections, and that the only way that there would be redress is to go to the federal legal system for it. And it is, just to be clear, this independent state legislature theory, it seems like that's consistent with the text of the Constitution itself in many ways, if you read the words directly. Yet for, at this point, well over 200 years, everyone has pretty much said, yeah, you can't trust state legislatures to be the final arbiter of just about anything. They need checks on every decision that they make. Nobody trusts them. And that's really just going back to James Madison, that you can't trust these state legislatures. They are going to be crazy. And in reality, that seems to be true. They need plenty of checks and balances at all times. So I cross my fingers that this theory will be debunked once again. But I suspect that it will be a zombie legal theory for as long as our Constitution is written the way it is, and one party thinks that they control the state legislatures. And I will leave it at that.
Great, thank you so much. So the last issue that we're going to cover tonight is not necessarily one case, but it's more about what we can expect from litigation going forward now that we've had the Dobbs decision. So I'm going to ask Lynette Labinger to take that on. Thanks, Lynette.
Sure. So unfortunately, there's no easy way to talk about this wide array of issues. And I apologize for having a smorgasbord approach to what I'm going to say. One of the things that happened with the Dobbs, a lot of the statements that were made were obviously very self-serving to accomplish a particular result, was basically that both in the decision and in the cheerleaders that followed, is this goes back to the states. And that is in many respects true, and has created a complete nightmare in terms of what is happening in the states. That also impacts the federal government and federal litigation as well. I want to start with where we are in Rhode Island, because we're in a pretty good place, because we passed the Reproductive Privacy Act in 2019, which codified Roe as a matter of state statutory law. Pretty good, because what the legislature provideth, it can taketh away. We have a pretty firm hand at the legislature that is pro-choice at this point. So it isn't in serious jeopardy right now, but that is always can change, because we don't have constitutional protection under Rhode Island Constitution. Because the last time the Constitution was amended to add clear equal protection and due process standards. It specifically said, but this can't be construed to confer some kind of protection for abortion rights. And so we're in a good place, but we're not in a great place. There's about 16 states, including Rhode Island, that have some form of abortion protection, either straight codification of Roe or some other language that is even more supportive. And in a lot of those states, which I'm sure you've all been hearing about, there's an effort to make them as some kind of a haven or support place for people who find themselves in need of reproductive care, being threatened with prosecution in their state, or they can't find any service provider because they've all been threatened with prosecution and have closed down. And a number of the states, either by statute or by executive order, have been providing some kind of protections for the local providers, the physicians, the clinics, etc., that they hopefully are not going to get prosecuted or effectively prosecuted or be required to provide information to the state where the person is traveling from, designed to prosecute someone for somehow interfering with that state's anti-abortion law by the individual traveling out of the state to secure services elsewhere. There's a lot of problems that underlie that are going to need some time to sort out, if they ever are sorted out, because you have issues with things like if you start in one state and you leave the state, with the idea of doing something that's prohibited there, and someone who's prohibited from assisting you does, either by providing you money or a plane or a travel fare, or even donates to a GoFundMe page, what happens next? And it's a bit frightening, and it is a strong deterrent for a lot of people. And that's why some of these shield laws and executive orders have been adopted to try to minimize that impact of those kinds of threats. In the same area, we have, the whole issue of there's a lot of procedures are done by medication. And unfortunately, the FDA has not been as vigorous as it could be in terms of approving the two medications that induce abortions the same way they've treated other medications. That may change, we hope so. But right now, there's a lot of states that are anti-abortion, that interfere with the prescription of those medications, which require that the medications be provided by an in-state provider. And there are developing workarounds, but that's what they are, workarounds, and they can always be fraught with problems. What's happening, I think, primarily on the litigation front is two prongs, well, three maybe. In the states that have anti-abortion provisions, there are numerous challenges ongoing to challenge them, either that the laws are vague, or much more proactively, that those particular states have some form of a constitutional protection that either directly recognizes a right of bodily integrity or privacy, or can be argued to do so because they have a due process and equal protection, and even an equal rights provision on the basis of gender. And there's litigation ongoing in a number of states about that. For example, in Michigan, there was an injunction obtained recently, a permanent injunction against the 1931 statute that kind of sprang up again because of language in Michigan's constitution. And there's expected to be a referendum on the ballot also that even more explicitly enshrines reproductive rights in the Michigan Constitution. You probably have heard about the Kansas provision. There's a provision in Kansas law that appears to support the right of privacy directly in the Constitution. And so the Kansas legislature put on the ballot during the primary the yes or no, shall we remove that? And that was soundly defeated. Florida has some very strong language in its constitution, but they keep passing laws that restrict abortion rights. And this is obviously destined for litigation in, I gather, a fairly Republican-friendly Florida Supreme Court. On the federal front, the federal government has indicated that it's willing to and has asserted EMTALA, which is EMTALA, and I won't tell you what it stands for, but basically it says that if you are a hospital and you receive Medicare funding and you have an emergency room, you must, you can't throw your patients out. It was really passed because people were getting thrown out of emergency rooms because they didn't have insurance. EMTALA was passed and said, you can't throw somebody out, you have to stabilize them. And the US has interpreted that to mean you have to provide immediate care. And they sued Idaho because Idaho's then impending anti-abortion law appeared to prohibit that. You'd have to sit back, and we've heard a lot of the horror stories about people having to sit back and wait because the doctors say, well, you haven't gotten bad enough that your life is in jeopardy, so we're going to have to wait, and you're going to have to wait until something worse happens. And the Idaho law was enjoined, but the flip version is that Texas sued the federal government on the basis of a administrative memo that said, here's how we interpret EMTALA, and got a federal judge in Texas to say that enjoin that enforcement of that interpretation. So there are a lot of things going on everywhere, many ways, all at the same time. And then on top of that, we have the final trump cards, which could, which is the supremacy clause, which is that if Congress were to either pass a law that enshrined abortion rights, assuming that it wouldn't be attacked as going beyond their rights, you know, to legislate in this area, then that could supersede all state laws that are less protective. And conversely, if Congress were to pass an anti-abortion provision, such as the one that Senator Graham wanted, that could supersede all state constitutions and legislation that protect reproductive rights. Very scary. And the one thing that is relatively certain at this point is that there's no place to fall back before the Supreme Court, because the Supreme Court has rejected the notion that these individualized decisions on what to do with one's own body in the area of reproductive rights finds a protection in the 14th Amendment, right, or in the right to privacy, or anywhere else in the Constitution. So we have a big challenge, and it's being mounted all over the country in many different ways. Thanks.
Thank you so much for that. And I just want to thank all of our panelists again, as we're transitioning out of the summaries of our cases. I just want to thank you all again for just really wonderful and comprehensive and very helpful summaries. It gave me, I mean, it gave me a lot of perspective on what we can be expecting in the upcoming months. So we are going to do Q&A really quick. We have one that was submitted to us. Make sure you submit any that you'd like. If we don't get to it, please email us. Please, please, please. We'd be more than happy to respond to any questions you have. But we do have one. During the Bruin hearings, Justice Alito asked why a permit was needed to exercise a constitutional right. Might we be seeing a SCOTUS that is more friendly to the right to keep and bear arms? Steve, do you want to try to quickly address that?
Sure, yeah, the answer is there's no question about that. The Bruin decision, which the questioner asked about, was one where the Supreme Court vastly expanded the reach of the Second Amendment, struck down a law that set some limits on how one could qualify to obtain a weapon. The court has made very clear that they are going to expand Second Amendment rights. I only wish they were as interested in expanding all the other rights in the Constitution, but the short answer is yes, you can expect that.
Thank you, Steve. I think we have time for one more, and I think that this last question is probably a very good summary of everything we've heard tonight, and maybe a really good way to kind of bring us full circle on this. So many of the conservative justices are expected to be on the court for a very long time. Realistically, what can be done to rein them in? So I think if there are a few panelists who want to give some short responses, we have time for that, and then I'll wrap up.
I would just say one of the things, and I'm not holding my breath on it, but in the past few sessions, when a decision authored by Justice Gorsuch, basically saying that under the state law, the federal laws prohibiting sex discrimination, that included sexual orientation and gender identity, because it's a it's on account of sex, that there's some willingness of the court to give broader rein to congressional enactments. That at the same time, they've been very stingy about allowing delegation to the administrative agencies, like they backed off on what the EPA could do. But that, to the extent that we can get legislation passed through Congress, that's clear. It might be hamstring them a bit. But they seem to be very willing to undo everything that they don't like, in a very frightening way.
Yeah, that is what it seems like. Thank you so much, Lynette. I think in the interest of time and making sure that we are keeping everyone on schedule, not keeping people past when we promised, I think that probably is all the time we have for questions. I do just want to bring Steve back one more time to say a few more brief remarks, and then we will close out. But thank you again. And Steve, take it away for a minute or however long you want to talk.
Just a minute. Again, I want to thank everybody for attending this webinar. I hope you did find it informative. I want to thank the panelists as well. If you're interested in learning more about either these cases or work that the ACLU is doing here, you have on the screen our website, riaclu.org. You have our email address there as well. As Hannah said, if you have questions either about what you've heard today or anything else, feel free to email us. And then finally, I can never end an ACLU program without encouraging all of you attending to make a donation or join the ACLU if you aren't a member. If you go to our website, just click the join or donate button, and we'd really appreciate it. It helps us put on educational programs like this. So thank you again, and back to Hannah to close things out.
Thank you. A lot of thanking in this last part of the program, which I think is important, but thank you so much, Steve. And thank you again to our panelists. Thank you so much to everyone who joined. Just as a final note, like Steve mentioned, if you have any questions that you would like answered, please feel free to email us. We will be sending out a follow-up email to this webinar, so don't hesitate to respond to that with your question. We will try to get it answered. We will send it to whoever we think is the most appropriate person to do so. And then that follow-up email will also include a link to a survey. we really hope you'll share with us what you thought of this virtual event. It's really helpful on our end, so that is always appreciated. But on that note, I just want to say one final thank you to everyone. Thank you for attending. Thank you to our panelists. Have a great evening, and we will hopefully see you next time.